David Bates is the Managing Director of Workforce Guardian, that's right. Sorry, too early for me. And he will, I'm wearing this puzzle tie, you know why? Because employment relations is like a puzzle to most of us. And if it doesn't work, then as you can see, the pieces drop off. So David will put all the pieces in place. Thank you, David.
Thank you very much. Okay, today is just simply a question and answer session. Please feel free to join in. After every question, by all means, put your hand up, don't be shy. Extract as much information as you can out of the next hour, and especially as we've got David here specifically for this particular session. All right, let me just warm up first of all, David. Just a quick question. I've just gone and employed a particular person, regardless of whether it's casual, full-time, part-time, and first day on the job. Should I even bother to actually get an employment agreement for that particular person who's now going to come and actually work for me for the next umpteen number of years?
Absolutely. The answer is yes.
I mean, just in terms of that employment agreement, and all I'm saying in terms of the employment agreement is simply a Word document stipulating the name, address, the pay rate of that employee, what their actual conditions are, annual leave, all their entitlements, what the superannuation entitlements are, whether they're on a probationary period, some sort of document to know that they're signing off on something. That's more what I mean by employment agreement.
Yes, you should definitely have something in writing. And in fact, it's important to note that in Australia, there is no legal requirement for an employer to give an employee a written contract of employment. So there's no written requirement in the Fair Work Act, for example, or in any state legislation that says you have to have a written contract of employment. But what we all need to know, and I'm sure most of you are already aware of this, we have legislation in Australia, the Fair Work Act of 2009, and we have these 122 things called modern awards. And also, part of the Fair Work Act, we have these 10 national employment standards. So even if you don't write down anything in a written contract of employment with your employee, those statutory requirements will simply be read in to the common law contract that you've created. So as soon as you engage someone to work with you, you have what's called a common law contract of employment, whether it's written or not. But if you don't write it down, and even if you do, all of these statutory entitlements get read into the relationship. So, if I give you a clear example, if I was to employ you in my business and I was to put nothing in writing, it still remains the case that you would be entitled to 4 weeks of paid annual leave per year and 10 sick days per year as a full-time employee, whether or not I write those down. So it's important that you do write things down, because otherwise there's a good chance that you'll miss out on providing some of these entitlements, and as some of you might already be aware, not providing those entitlements carries a penalty of $33,000 per breach maximum.
Okay. For things like other certain clauses, which I know these are things that we kind of include. We've got sensitive information in our on our files, whether it's a probationary period, all those sort of things, which may be a little bit outside of the Fair Works Act. Those things that you think you would, I guess, recommend to actually include in a written agreement?
Yeah, absolutely, and that's actually a really good point, because what you've now taken us to is the fact that all of these statutes, the legislation, the national employment standards, these modern awards, they of course all provide entitlements to employees. None of those documents talk about you as employers and your rights. So if you have an employee and you don't have anything in writing, all you have done is engage them and recognised all of their rights at law. And if you don't create a contract and you're not putting in clauses around things like intellectual property, non-compete clauses, or clauses in relation to building security or workplace requirements, a code of conduct, for example, if you don't have those things in the contract, then you haven't put into the contract anything at all that's in favour of the employer. So you've got a very uneven employment relationship right from the start.